facts accurate?
Yes, Your Honor.
Did you get into an argument and into a fight with SB?
I don't believe so.
You don't think you did?
I just know that when she dropped me off, she was yelling stuff at me when I drove off.
So what did you do?
I just drove off.
You didn't do anything?
No.
You didn't provoke a disturbance?
No.
Good, we're going to trial. Thanks. We'll set this matter for a trial. Okay. We will go on the record in the matter 24 CM 202, State of Wisconsin versus Andrew Cote. The state appears through Assistant District Attorney Holly Rockow in person. Mr. Cote appears in person in custody with counsel Joel Beliski. We're set today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Mr. Beliski, can you please recite the agreement for the record?
Yes, Your Honor. Mr. Cote has agreed to plead to one count of misdemeanor disorderly conduct with the remaining counts in the complaint dismissed and read in, and a joint recommendation by both parties for court costs totaling $443.
And I believe he was in the process of a revocation. Was he revoked or did?
Yes, Your Honor. As of yesterday afternoon, the final decision from the administrator came in and he has been revoked and he will be sent to Polk County for sentencing.
Okay. And what charges was he convicted of in Polk County?
I believe they were substance use related, Your Honor. I was not originally opted into that case. That was my predecessor, Mr. Pollack. Unfortunately, I cannot speak to any detail as to the nature of those charges.
All right, thank you. I can just pull it.
At first glance, it's just a judge confirming facts, a few hesitant answers, mild misdemeanor, and a deal for court costs. But listen closely.
The defendant's pauses, the vague responses, the almost too casual denials.
They hint at something darker lurking beneath the surface. The prosecution thinks they know the story. The defense believes they've already locked in a sweet deal. The judge, he's just moving through the docket. But in a matter of minutes, one unexpected voice will turn this whole proceeding upside down, revealing a hidden history of abuse, control, and violence that never made it into the official complaint. And the courtroom will have to decide, stick to the deal or rip it apart.
First, Ms. Rockow.
Your Honor, Mr. Schmidt negotiated this case with Mr. Pollack and Mr. Flasky, but based on my review of the file, I believe that this was based upon the facts and circumstance surrounding the case being relatively minor in terms of the disorderly conduct. There was, of course, the violation of the bail, but that was the Polk County bail. And so it looks like that was all resolved with his latest revocation. So those bail jumps being dismissed and read in is appropriate for that reason. And I don't believe that any additional confinement or supervision is going to be necessary as he is facing that sentence for the revocation.
Okay. All right. So we do have victim SB in the courtroom here today, and Ms. Bauer, SB would like to make a statement. Is that correct?
Yes, Your Honor.
SB may come up here and have a seat at the black desk, and you may provide a statement. If you are going to read something, please read it very slowly so my court reporter can take everything down.
Of course.
Here's the setup. Plead guilty to one misdemeanor disorderly conduct. Pay $443 in court costs, and the rest of the charges disappear. Sounds like a parking ticket compared to what we usually see. But in the world of criminal law, deals like this often hide deeper layers. Sometimes it's about avoiding trial costs, sometimes about lack of evidence, and sometimes it's because key details never made it to the prosecutor's desk. Right now, both sides think this is just another minor case. But if you've been watching courtrooms long enough, you know minor cases can be ticking time bombs waiting for the right person to speak.
At me. Seconds later, he would spit in my face. but once again, made it up, told me he would never do it again. But just a couple hours later, my world flipped around. On October 22nd, about midnight, we left the friend's house and he drove to a parking area in Grantsburg. I ended up falling asleep in the passenger seat, like I always had. He ended up waking me up to ask me where the drugs were. I handed him what he had wanted, and I went back to sleep. He woke me up again and asked me for the other bag. I said I gave him everything I had, and I didn't have anything else. He got angry and started firing the flare gun out the sunroof. The second time he woke me up, he asked me once again, and I told him this.
And then it slips out. Polk County charges for possession of amphetamines, cocaine, repeat offenses. This isn't just bad luck, it's a pattern. When a defendant's record shows repeat drug possession alongside bail violations, it changes. How a judge and the public see the current case. Patterns tell a story. Right now, the story says, this isn't a one-off argument. It's part of a bigger, more dangerous lifestyle.
Taking my phone and with his two hands, literally ripped it in half. The fourth time he woke me up, I kept repeating what I had told him every time. And this time I looked at him and I looked in his eyes and they were black. It was like Andy was gone and someone else took over. The next thing I knew, he started bashing my head against the passenger window. And all I kept thinking was, I have to get away, otherwise he's going to kill me. So I had got him calmed down enough to where he would drive to Dollar General where the van was parked. We were going to move it, but we decided he didn't want to because he was getting tired. He let me drive the car, and I knew that was the only way I was going to get out. I drove the car to the Frederick Trailer Park, where I knew I would be safe. I parked in the front entrance and stopped. He woke up and started yelling, calling me every name in the book, but I was only able to grab my purse, and that was it. I started walking to my friend Jen's house in the park, and I got there and she asked me if she...
This is the turning point. The legal back and forth stops, and the victim SB takes the stand. Her voice cuts through every legal technicality. For almost a year, she says, this relationship was a nightmare. Not just arguments, not just yelling, but months of physical assaults, threats, and terror. A car manual thrown at her head, spitting in her face, ripping a mirror off the car and hitting her, smashing her glasses, ripping her phone in half with his bare hands. And then, the part that chills everyone in the room, having her head bashed against the passenger window while she thought she might die.
But I have nightmares every night, every time I sleep, of what he did to me. I am in therapy almost either 1 or 2 days a week, and I will be on therapy for at least 3 years, she said. This was 6 months ago, and yet it still gets to me every day. I don't know how I'm going to move on from this. So I'm asking you for some stipulations. 90 days in jail, no contact with me, my property, or my roommates, no possession of firearms, anger and drug treatment, and probation. Safe. And I will be putting 2 restraining orders on him for both counties. I can't go outside by myself. I can't go to the store by myself. He's already threatened me enough. Thank you.
Thank you. just a bit of information. You only need one restraining order. It covers you everywhere.
Okay,
So
Thank
you don't
you.
need to go to both counties. Thank you for your statement.
thank you.
And for the record, and I'm sure that, well, maybe the state had more information, but that's not any of the information that is contained.
Daily panic attacks, prescription medication for nightmares. It's ongoing therapy. She can't even go to the store alone. God, all she asks for is 90 days in jail, no contact. In treatment for anger and drugs. Think about that. She's not asking. 4 years behind bars. She just wants a small measure of safety and accountability. Meanwhile, the prosecution's deal doesn't even give her that. This is where plea bargains meet the real-world impact of trauma. And the two don't always line up.
Information that the state had when this case was charged or when this offer was made. It's not my file, but from my review, I didn't happen upon that, what was described just now. So based on the facts that are contained in the criminal complaint.
And again, and I'll state, you're probably hearing or seeing it for the first time as the court is, because the criminal complaint is one small little paragraph that just describes a fight that occurred and that it may have escalated a little, but none of the detail.
Right. But Your Honor, again, Mr. Cothi has been revoked in Polk County on some more serious charges and is going to be presumably serving a jail sentence. I think at least one of those had some stayed jail time. So I think that he's going to remain in custody for a while.
And here's the bombshell. The judge admits the criminal complaint barely mentions anything. Just a vague argument. No details about the assaults, the head bashing, the destroyed property. That means the official record. The thing prosecutors, defense attorneys, and judges rely on didn't have the full story. This is why some charges get reduced to misdemeanors. Not because the violence didn't happen, but because the right details weren't collected or passed.
Also, maybe the police were not aware of the extent of the argument or what occurred that night, because otherwise I'm questioning why a battery wasn't charged.
Right. I don't have any information about bruising or pain or injury in the file as I review this.
All right. Okay. And he is being revoked, and I'm taking judicial notice of 24 CF 15, 24 CF 224, and 24 CF 310 Polk County matters, in which he has now been revoked on those matters and will go face sentencing in Polk County. I believe in those cases, there is no stay jail time. That was that fictitious thing that some judges do, and they fictitiously say, I'm having that fictitious conditional jail for probation to use if they wish to do.
Understood.
And so with regards,
The prosecution admits they didn't know the full story when they made the deal. The judge questions why battery wasn't charged. But here's the legal bind. Once a plea deal is agreed to, undoing it is complicated. The defendant is already facing prison time in another county. In the prosecutor's mind, this case is covered by the other sentences. But for the victim, and anyone hearing this testimony for the first time, it feels like a missed chance for real accountability.
deal with in Polk County, and you were under bond conditions in Polk County when you violated your bond here by engaging in the criminal actions here in Burnett County. And for the record, and this is, I guess, for the victim as well as you, Mr. Cothi, for you to be aware of, and perhaps the reason why these were simply charged as disorderly conducts is because of the little bit of information that was provided the day of the incident, at least that I have in front of me. And usually what's in the criminal complaint is what has been provided to the police in the police report. So there's not much. This is the first time that I believe perhaps even the state is hearing the depth of what may have occurred that night. So he's pleading guilty to one count of disorderly conduct, is that correct? And the other count will be dismissed and read in, and he's facing the other charges in the bail jumps in Polk County?
To my understanding, Your Honor, that is correct. It's a plea for one count of disorderly conduct with the...
In the end, Andrew Cody pleads guilty to one count of disorderly conduct. He'll pay court costs here, serve his other sentences in Polk County, and the cycle of paperwork moves on. But the victim's statement will stick with anyone who heard it because it revealed how much can be hidden in a case file and how the justice system can miss the true scope of a crime. So what do you think? Should this plea deal have been scrapped after hearing the victim's story? Prison time in another county? Make it fair.
Here in the maximum sentence for a charge of disorderly conduct has been vastly exceeded. It's he's set for close to double the amount of time he would for the maximum sentence on this. The public, I believe, has been sufficiently protected. He will continue to reside in custody, awaiting sentencing after revocation. I believe he will be returning to active supervision for his Polk County charges as well. In entering this plea, he is taking accountability for this and does wish to move on. For those reasons, I would ask the court to adopt the joint recommendation. Thank you.
All right, can I have the plea questionnaire waiver of rights form, please?
Yes, Your Honor. May I approach?
You may. So I have in front of me the plea questionnaire waiver of rights form. Mr. Coakley, did your attorney go over this document with you thoroughly?
Yes, Your Honor.
Did he go over it word for word?
Yes, Your Honor.
And do you understand it completely?
Yes, Your Honor.
If you didn't understand it, did you ask him to explain it?
Yes.
And he did so?
Yes, Your Honor.
So you're 37 years old, you have 12 years of schooling, you can read, write, you understand the English language.
Yes, Your Honor.
That's your signature on the second page.
Yes, Your Honor.
You're pleading guilty to one count of disorderly conduct, is that correct?
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
No mental illness or disorder and no alcohol, medications, or drugs?
No, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Did your attorney thoroughly go over these rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up these rights?
Yes, Your Honor.
Do you need me to go over these rights with you in any more detail?
No, Your Honor.